By the end of this video, you should better understand the basics of estate planning and why it's so important to protect your assets this way. If you're not sure what estate planning really is, think of it as a form of risk management. It's a way to protect and guide your loved ones should you die or become incapacitated. During these times, giving clear instructions on how to handle your affairs, especially things like bank accounts, investment accounts, and real estate, is the easiest way that you can remove frustration and doubt during a stressful situation, no doubt. The most common estate planning document that you hear about is a will, yet less than half of adults in the US even have one. However, estate planning can be much more than just that, and we can actually plan for anything that would require our loved ones to step in and handle our day-to-day affairs. Estate laws also vary by state. Whatever documents you have drawn up need to meet state requirements, or else the documents can be voided. That means if you move to a new state, you may need to update your documents as well. So just a heads up there. Estate planning can be so time-consuming and honestly confusing. So let's break this down. First, with some basics. Organize your account logins and passwords. Have all of your passwords set up in a password manager, like 1Password, for example, which is my personal favorite. Migrate all of your two-factor codes from apps like Google Authenticator to 1Password or whatever password app you use to make it easier to share secure logins. Organize important documents. This should include things like your insurance documents, medical records, a list of financial accounts, and any important contacts. I use Google Drive for this, which is, the easy free system. Decide who gets access to your documents. This doesn't have to be the same person you want to handle things like your finances or healthcare decisions. Google has an inactive account manager, which is like a kill switch for your accounts and makes it easy to get access to your account if you're inactive for a long period of time. For everything else, you can rely on your password manager's family access and emergency kit. Create a last will and testament. Consider this your final wishes for your possessions, dependents, and arrangements. This one is especially important if you have any valuable assets like money or real estate and want to specify where they go. It's also important if you have children or pets so you can designate who you would want to look after them. It can also include how you want your assets divided, who gets what portion of your assets, special wishes, and other designations like charitable donations. If you set up a full estate plan, then this will be part of that. Designate your beneficiaries. While you can specify what happens to your financial assets in a will, one major exception is that in most cases, if you've specified a beneficiary on a specific account, which is most common with retirement accounts and insurance policies, that designation will take precedence over your will. In many cases, we set these up when we first open the account, so make sure to double check that you have the right beneficiary specified. All right, let's talk about the full estate plan. The full estate plan is the next level of family planning because it helps cover other circumstances than just your death. You also need to consider any event that would leave you unable to make your own decisions under your own capacity. For example, who do you want to handle your affairs if you're unconscious in the hospital? How do you make sure your medical or financial wishes are executed? How can you help your loved ones avoid the hassle of probate court? There are some great online or do-it-yourself options, so don't necessarily have to go through the family attorney for this one. However, if you have a large estate with complicated wishes, lots of possessions, or just a blended family like kids from multiple marriages, second spouses, etc., you may want to work with an estate planning attorney. And before we talk about how important that is, hit the subscribe button so you don't miss out on other videos like this. Imagine if you're not watching this and you'd have no idea how to do estate plans. Hit subscribe and follow along. All right, so here's what a full estate plan commonly includes, and then when and why it's important. The Revocable Living Trust. This is the hub of your estate plan and specifies the management, control, and distribution of your assets during life and after death. A trust can offer more control than the will, especially when it comes to how and when your assets will be distributed. Another benefit of a trust is that it can help prevent your loved ones from lengthy and costly proceedings in probate court. For example, in California, estates valued over $166,250 have to go through probate when the assets are not held in a trust. While some trusts can be quite complicated, have you watched Succession lately? A basic revocable living trust is easy to set up, doesn't change your tax situation, and is easy to revoke, hence the name. Pour over will. So your trust is your primary tool for distributing your assets after you die. But you might not end up having all of your assets titled in your trust. Maybe because you forgot, or maybe because that app online doesn't even support it. So think of a pour-over will as a kind of safety net that takes any property you didn't put in your trust while you were alive and transfers it into the trust. Advanced healthcare directives, living wills, and medical powers of attorney. These detail how you want your medical care approached if you haven't yet made those decisions yourself. Like what kind of medicines and treatments will you allow or not allow? Who is allowed to make those decisions for you? When do you want to cease life support, should you get to that point? Those are the types of questions that this handles. Financial power of attorney. Much like a medical power of attorney, a financial power of attorney designates how you want your money handled while you're incapacitated and who can handle that for you. Remember, bills don't just stop in the event of an emergency. You gotta have someone handle that for you. So having a financial power of attorney in place means less worrying about it if your bills are getting paid on time and more time focused on the healing. Finally, you may also want to consider writing a letter of intent. The letter of intent is an informal document that will give your loved ones important information that is not covered by your estate plan. Letters of intent aren't legally binding, but can be a nice complement to those documents. For example, if your trust dictates that your children wouldn't receive any inheritance until, let's say, they turn 30, it might also state that the trustee in charge of the money has the authority to make distributions for health, education, maintenance, and support. In this circumstance, a letter of intent could then give the important guidance like wanting to support private education or providing them with funds for their first down payment, for instance. All right, let's go into the advanced tactics. When most people think of estate planning and trust, it's often that tax avoidance. However, in 2022, the estate and gift tax limitation is a little over $12 million per person, meaning a married couple could transfer up to $24 million in their lifetime before being subject to the high estate tax rates. So realistically, unless you think your assets will approach that level, and if they do, that's great, but for most people they don't, you likely won't need any advanced estate planning tactics to avoid estate or gift taxes. With that said, it's still valuable and interesting to learn about ways to legally minimize taxes if you were to cross those limits. Grant or retained annuity trust. An irrevocable trust you would establish to minimize estate tax on highly appreciated assets, that's investments or businesses. It allows you to transfer assets into the trust and then receive annual payments of a fixed amount of principal and interest for a prescribed number of years. Any appreciation that stays in the trust can then be passed to your spouse or children and avoids estate tax. Charitable remainder trust. In a charitable remainder trust, you typically transfer appreciated assets into the trust and retain a stream of income from the trust. But unlike the previous mention, the beneficiaries at the end of the trust term are not family, they are charities. However, even though the charitable gift is not made for years, you get the charitable income tax deduction when you first transfer the assets into that trust. Family limited partnership or limited liability company. This works by transferring assets into a corporate entity and making your heirs limited partners or non-managing members of the LLC. And because they don't have any management control or ability to demand distributions, the value of their ownership of the business is only a fraction of the value of the assets owned. Therefore, you can transfer the interest to your children at a discounted value and minimize estate taxes. Also, because you're a managing member, you still maintain control of the assets and you can receive distributions throughout your life. Irrevocable life insurance trust. All right, this tactic allows you to avoid estate tax on life insurance proceeds by setting up a trust to purchase life insurance on your life, or you can transfer an existing policy. You also need to gift the trust the cash necessary to pay premiums on the policy. Then, upon your death, the payout is paid into the trust and not subject to estate tax. As with anything, there are some certain things to be aware of so you can get your information together. Again, estate laws vary by state, so whatever documents you have drawn up need to meet state requirements or else the documents can be voided. That means if you move to a new state, you may need to update your documents. To all the parents out there, start having conversations with people you would like to become guardians for your kids should you pass away while they're still minors. It's a big responsibility, and those people need to be aware of and agree to your wishes well ahead of time. Check your employer benefits for low-cost, discounted, or free legal services. This can cover things just like estate planning as well. Remember to include important contacts like your boss or HR rep, financial advisors, landlord, or tenants. Don't forget pet care in your directives. Make sure you follow through with notarizing and filing the paperwork. The last thing anyone wants to deal with is finding out a will is not enforceable because someone didn't get it notarized. You know, in estate planning, it's not just for yourself. Many of us are getting to the point in life where our parents and grandparents are noticeably aging. We need to start thinking about and having these conversations about their wishes and how to best support them. If your parents didn't have the chance to establish an estate plan or some sort of central information hub, I highly suggest having this conversation with them. Yes, it is uncomfortable and can bring up many emotions. However, if anything happens, you need to know the same thing for them as your family would need to know for you. I'm Tony from Wealthfront. Take care.